is that I see a lot of people, I guess, a lot of challenges when it comes to the application. My name is Ahmed Elnaggar, and this is Monday Legal.
Welcome back to a new episode, a special one of Monday Legal. Today we have not one guest, we have two. We have Veronika Chastukhina, a lawyer from Elnaggar & Partners, and we have Mr. Mohamed Ibrahim, who is a lawyer from Ibrahim & Partners. Thank you very much, both of you.
Thank you for inviting us.
Today, our special episode is mainly focused on real estate. Veronika, in her experience, she had a big experience working as in-house lawyer for one of the biggest real estate brokers in the UAE. Mohamed as a litigator, a fighter in court most of the time, and he handled quite a big amount of legal disputes that relates to real estate. And let me start with Mohamed. Thank you very much for coming today. And can you please tell us the latest update in regards to the real estate transactions? I understand that the Dubai Land Department have made the decision to abolish the requirement of an NOC in real estate transactions. Can you give us an update about this?
Well, first of all, thank you, Ahmed, for having me again at the very famous Monday Legal. Actually, the new resolution that have been issued by the DLD recently that all the market actually is discussing nowadays is that they made some kind of a distinction between when do the owners or the landlords of properties in the UAE, if they are selling their property, they need an NOC from the developer, and when they don't need an NOC from the developer. So the old situation was that if you have a property, whether it's under construction or handed over and finished, if you're selling this property, you need to get an NOC from the developer before you sell it to any third party. What the DLD has now made in order to ease up the process for the investors is that they made this distinction. If it's a handed over property and it's finished, then the project is fully completed, then you don't need an NOC from the developer, and you can go straight away ahead with signing a sale and purchase agreement and transferring the ownership without an NOC. However, if it's still under construction by any percentage, even if it's 1%, then you still need to obtain an NOC from the developer for the sole purpose that this property might be, for example, under mortgage, still there is a finance, any payments to developer in terms of the payment terms between you and the developer. So you still need to get the developer permission before you sell your apartment.
Thank you very much. I think what was historically the practice, even for handed over properties and ready ones, the need to get the NOC from the developer was related to the fact that there is still a continuous obligation of the landlords to pay the service charges, and usually before the owners committee regulations were in place, most of the service charges were still collected by the developer. What's your opinion? Whose obligation was to pay for the NOCs when there is a real estate transaction? Since you're coming from a company or you have a big experience with a company that was handling these transactions, was it the buyer or the seller in the real estate transaction?
Yeah, normally from the practice, it's always the seller who's supposed to get the NOC. But sometimes when it was off-plan project, not the ready to sell, some of the sellers, they don't have money to pay anymore. So they were asking the buyer if they agree to actually pay the outstanding payment and pay for the NOC, because basically they had no money at all on their account here in Dubai. So they couldn't support any payments at all to the developer. So, and it's actually a problem, because we had a case already that involved somebody who agreed to that, the buyer, and they paid the outstanding payment, the last payment to the developer, and then the seller just dropped off the case. They waited until the Form F expired and they sold the property to somebody else.
Making different a little like additional profit on it?
Yes, but also for me, I think it's good that they actually change the law or the procedure of getting the NOC, but still you can have a surprise on service charges, as you said. So you can buy the apartment, which is already used by the seller, and maybe he didn't pay or she didn't pay the service charges for some time, and it can be a big amount, and then you need to talk to the company which is controlling the building. And then you need to prove that it was not you, that you bought the apartment on this date, this is your contract, and you're not responsible for the service charges. And it's actually also not a very easy part.
Yes, I agree totally with this, because in real estate transactions, they usually don't even issue the NOC unless the existing landlord have a credit, not just up to date with the service charge payment. They ask them to pay 3 months or 6 months in advance to make sure that the property is handed over to the new buyer, to the new landlord, free of any liability, and then there's always a compensation in the end of this amount between the buyer and seller. Have you seen any cases that went to court in this regard, that there is a conflict between a buyer and seller because of service charge or NOC or something like that?
Well, to be honest, this is very recent. We're talking about something that have been issued in the market for like a week or so. So this has not been tested yet, I'm 100% sure. But let's say if we look at it from a pure civil law perspective, so the situation where you need to hand over an NOC to avoid all of these problems like mortgage, service charges, whatever payments need to be, maintenance for the property, this NOC was in favor of the buyer before, because the buyer makes sure with this NOC that there is nothing on this property, and he's taking the property free of any charges, free of any liabilities. But now what the legislator has done, which is the DLD, is that they put more risk on buyers. So if you're a buyer, you're buying a property, fully handed over, finished, it's your obligation to do your due diligence. You know, in normal transactions, if you're buying a company, you don't go and tell the owner of the company, give me just an NOC, a piece of paper that you don't have any liabilities, and then you take over the company, and all of a sudden you have cases before the courts, you have judgments against the company, you have debtors, creditors, you know what I mean?
This is a little bit different topic, because we cannot compare somebody who is buying the company and a property. Some people are buying the property for 600,000 dirhams with mortgage, and some of them don't even speak English. So it's kind of the brokers who are supposed to help them, or maybe
then it's more liability on the brokers, more liability on the buyers to do their check, to do their due diligence, because it's like they say, you snooze, you lose. So it's your liability.
This is a big topic when we talk about real estate transactions. A lot of buyers, a lot of investors in the market, they do not do a proper due diligence on the deal, and they rely 100% on their real estate broker to do this due diligence. However, in my personal opinion, me as an investor or as an end user who are coming to the market, that is to buy a property, I need to start my due diligence process by checking the broker himself, to checking the company who is doing the real estate deal with me first. This is part of the due diligence that I have to do. And then afterwards, I have to do my proper due diligence on the property itself. So coming from a transactional side, what can you advise for real estate investors to do when they are approaching a deal? What kind of due diligence they have to do on the brokerage firm and on the property itself before they buy it?
Okay, I think first of all, it's the most important thing from my experience as a Russian-speaking lawyer. I had a lot of Russian clients, and if you don't understand the language, use any translation you can. For the contracts, for the offers, for any documents, Google Translate it. It's very easy with the mobile phones we have right now, so it's not a big problem. Then it's also very important to check the broker cards. Are they valid? Is this broker a real broker, or is just some representative or a person who gonna refer you to the broker company and just get the commission as a referral, or like through the referral agreement, something like that, which is also happening all the time. And they're not brokers.
Yeah.
But then on your Form F, you have a name of some broker whom you never saw in your life, just because it was a referral to the company. This is the first thing. You need to understand whom you're working with. Translate all the agreements, all the forms, all the documents. And then if you don't understand something, you can always approach a lawyer, a consultant, legal consultant, somebody who has an experience in this, or even ask the brokers, do they have a lawyer in their company, just to talk to this person and see, okay, what's pros, what's cons, do they understand this and that correctly? I also went through the cases where a lot of buyers, they didn't even read the contract. They told me, oh, I was told that by, for instance, by the developer, I need to sign it right now. And they don't even
they
read.
put them on under a lot of pressure. I don't know why.
I told them, you no need to sign this, or even the Form F. I said, okay. So I assisted few of them. I said, send me first the number for the Form F so I can open it and I can read it.
Exactly.
And I'll make screenshots for you. I will flag things you need to understand. And then we'll talk more. You don't need to sign it right now. And they said, no, we need to sign it now. I said, no, there's an end date in the Form F.
Yeah, they always put them under pressure that if you don't sign now, someone else will take the property.
Yes, exactly.
And it's insane what's happening in the market, because you're an investor. Why do you feel you're under this kind of pressure? Like, if this property got sold to someone else, you have other properties.
Yeah, especially
and if this property is too valuable for you, just as she said, appoint a lawyer.
Yeah, especially if it's like 3
That's
million
why we
dirhams
exist, you know.
Right.
And what kind of, what do you think, Mohamed, the kind of due diligence that they need to do on the property itself? Because we spoke about the due diligence that we need to do on the real estate brokerage firm, but on the property itself, what kind of due diligence they need to do, or even what do they need to check when they sign a deal, even with the developer for off-plan property? What are the terms that the buyers, end users, or investors should take care of?
Well, if you're buying let's make a clear distinction in here. If you're buying, let's say, not directly from the developer, like a secondary market, okay, these things that you need to check as a due diligence on your side is much more different than if you're buying directly from the developer, which is a proper developer, well known. So, for example, if it's a secondary market, first of all, you need to check if this property actually belonged to this person or not. I know, like, it seems like a very basic thing, but believe me, I'm coming from the dispute world and we see insane mistakes, okay? So you need to check if he actually owns this or not. You need to see a title deed, okay? If the title deed has more than one name, you need to check if the people on the title deed, and I'm sorry to say this, they are alive or not, okay? Because we have seen cases where the title deed says two persons, one man and a woman, one man and his wife, for example, and his wife passed away, and there are legal heirs, and you're not aware of this. Whether the man can act as a proxy for the legal heirs or not, you never check this. And then you pay the money to him, and then the legal heirs 2-3 years later on, they come in back against you with some kind of a case saying you misrepresented us, you give all the money to our father, we had the right at this time, our father didn't have a proxy, he was not the legal heir for us, for example, due to any kind of, let's say he was a drug addict or alcoholic or anything, and the court had the legal heir as our grandfather, not our father. So you get surprised of what you see in real life. So you need to check who are the owners. 2, if the owners are being represented by proxy, like for example a real estate agent, as she said, you need to check that this real estate agent is actually a real estate agent, because if someone can actually screw you and he's not the owner, then the agent can easily tell you, I'm the agent of this person. If he has a proxy, you need to check his POA, okay? All of this stuff comes together as identifying who are you buying from. And then you can check the normal stuff, if there is a mortgage on the apartment, if there any financial liability, if this has been, is it rented, if there is a continuous liability or not, there's service charges, any debts, all of this stuff need to do. So my short advice is that, again, get a lawyer. If you're investing this amount of money, seek legal help. It's as simple as this.
Going back to the transactions, I know very well that the Dubai Land Department and the Real Estate Regulatory Agency have made it very easy for end users to be able to check and verify the documents. I understand that through the Dubai Land Department website, you can verify the title deed if it's correct or not. Even there are some applications where you can go and verify the ROI, even when the brokers are talking about amazing promised profits in rent, on rental yields, or what you can sell this property afterwards, and so on. They tell you that this property is amazing and it's sold below market. You can actually check the transactions in the market and verify this information. What can you advise, or what sort of platforms that the government have made available for the public to check and verify the real estate transactions?
Okay, so on DLD platform, you can actually go and find the information on the apartment which you are buying. You can put but you need title deed for that. So you put the number of the title deed and the name of the person, and then it says to you maybe it's blocked, or there's something wrong. Actually, but there's the other thing. If it says it's blocked, then you don't know why. You can't know why. It doesn't say. It's just like one line.
But it's a red flag.
It's a red flag. So also had this issue with the brokers, where I'm saying, okay, it says on this website that it's a blocked property, and they say, oh, okay, so what can we do? I said, ask the seller what's the issue, because only the seller can tell you what's the issue, and they're saying the seller doesn't know. So then actually people were trying to sell such apartments not via the Form F, but the old forms which you sign with your hands. Those forms.
Yes.
And they're like, yeah, but we already had signed this form. And I was like, but this is not, it's something which is not valid, because who can prove that it was your signature there?
Yeah.
Nobody. That's why you have an OTP and everything for the Form F. So that, and unfortunately, I forgot the name of the other platform where
Dubai Rest?
There is another platform. I used it a few times. It showed you when was it's already an apartment which you have ready to sell, and somebody used it before with the rent. So you can check what was the previous rent, who rented it, and what's the previous rent.
It's Dubai Interact.
Dubai Interact, yes. It is Dubai Interact. Actually very comfortable, but sometimes it's hanging, you need to reload it again and again. But it shows you exactly, it doesn't show you the names, who were renting the apartment, but the prices and which year it was rented and what was the price for this apartment.
That's, of course, a part of the due diligence that real estate investors and end users should try. There is a lot of information. The government have invested a lot in these platforms to make these information available for the public to use.
One thing I would like to add on this as well. So when I told you we have to draw this distinction if you're buying a secondary market property or under construction property directly from the developer, I think it's very, very important that people understand that if you're buying directly from the developer and following your decision that you decided that, okay, you will invest this amount of money, you know exactly the property, you have to make sure that you sign an Aqudi, okay? After that, Aqudi is like the initial agreement with the developer that registered you as a buyer of this property. Okay, you haven't signed the final contract, you haven't completed the final payment because it's on an installment plan, but at least once you sign Aqudi, okay, you have the right as a legal buyer of this property in relation to anything regarding the terms and conditions of the SPE. So this Aqudi, as per the real estate law in here, the period for signing Aqudi is 6 months. So if the developer doesn't actually initiate the signature within the first 6 months, then you are in the red zone. There's something wrong with this developer, okay? Because all the big developers, all the well-known, the established developers know this rule, okay? If after 60 days you didn't sign the Aqudi, then the sale and purchase agreement is null and void. So this is a very, very, very clear point in the mind of all the developer. So if the developer doesn't do this, there is something wrong
It
with the
means the
developer
project
procedure.
was not yet registered.
Project not yet
it.
registered.
There
There is
is
no
no
approvals
escrow.
on the initial plan.
Yeah.
There is no approval on the escrow. So it's kind of a very, very big flag, red flag telling you there is something wrong with this project. So 60 days and one plus invalidate the agreement. It's your right. Pull out, go to another project.
You know what I did a few times? We had the developer like this, and they were asking people to pay the installments,
Yeah.
but there was no. We call it akud.
Yeah.
You call it akudi, okay?
Yeah.
In Russian world, we call it akud.
Oh, good.
So a few of my clients, like the clients from the previous company where I worked to, they stopped paying the installments, and the developer was asking them, "You need to pay the installments. This is the fine." So surely I cannot send an email from myself. So I just prepared the email from the client to send out, saying there is no akud signed.
Exactly.
So I have full right not to pay any installments, and I'm not going to pay any fine. And they agreed to that.
100%. 100%.
So,
It's
but
very,
yeah, but
very
you need
red
to
flag.
fight, because first they say no, and then you start to use the law,
Yeah.
the articles, and then they're like, okay, they see that
And they start giving you excuses. It's like, yeah, we still haven't registered. We still didn't get the approval.
It says in
We're
the contract
preparing the
that
contracts,
they
preparing the
said-
SPAs. There is a lot of investors. The launch has finished. We just finished the launch, and there is a lot of units. You just need to wait with us until they get as much as they can of the installments. Of
Yeah,
the
because
initial
they need to get
installments.
40%
Exactly.
for the bank.
And then you're hooked. And
Yeah.
then the project is cancelled, which we will talk about later on.
Oh,
Tell me about this, because it's very important for part of the due diligence that we need to take care of when we're buying a property directly from the developer. At what particular stage the developer would have the escrow account? Because in many cases, the reservation form is signed, the down payment is done, and this money goes to the bank account of the developer directly. When can we know that this project have an escrow account, or the project is registered? Does the land department, for example, issue a certificate for this escrow account being established? And can the buyers ask for it as part of the due diligence?
Actually, this is a very initial stage. So you cannot start selling as a developer. You cannot start selling, even if it's under construction, unless you complete this stage. This is a prerequisite for the developer to start selling. Assuming that you can book your property, you can pay the advance payment, they send you an invoice, they issue a receipt of funds, then this assumes that the developer has checked all the boxes with the DLD and took all the approvals. They have their own escrow, and you should be paying to this escrow. Like, don't pay directly to the company bank account. Like, you need to have some common sense. You know what I mean? So if you're paying $500,000 of advance payment, just double check if this account is an escrow account or not. And it's clear to everyone. But if the developer doesn't do this, then just one complaint at the DLD will help everything.
So this is one of the things that we need to address to all the investors and end users. If you're buying an off-plan property and you realize that the developer is asking you to pay to their operational bank account, is not an escrow account that's connected to that project, you can say no. And this is a red flag not to pay and not to continue with the deal.
one more red flag.
Go ahead.
Second red flag.
With respect to the booking form, as you mentioned. The booking form is created only to put the money for a specific unit, and it doesn't mean the developer should sell it to you or not. You just have a right, like, to book it, to buy it in the future. And it should have only one amount, something like 20,000 dirhams, something like that. This will go to the corporate account of the developer. But then, if in the booking form, you start to have an installments, like in the sale and purchase agreements, that after 1 month of signing of booking form, you paid this amount, 10%. Then after 2 months, 10%. So basically, it looks like an SPA. This is totally illegal. And everything goes to corporate account. And I saw it already.
Yeah.
And if there were a lot of people who got into this, and I will not call the developer name, but it's a very famous developer here in UAE.
You wanted to speak to us about one of the cases, or one of the common things that might happen to anybody who's buying a property when the project, for whatever reason, gets cancelled.
So cancelled project it's a very big topic in the UAE. Hopefully nowadays we don't see that much of cancel project because the economical status in the UAE is flourishing nowadays, of course. Thank God for this. But we still see some kind of like remains of the old past. So in case of a cancel project, everyone asks, what's a cancel project? How a project can be canceled? So basically how it works is that if the developer somehow get like financially cannot continue paying or financing the project for any reason, okay? There is a lot of small developers. What happened is that they cannot liquidate any money from the escrow account. So the DLD actually stopped them based on their completion status and timeline of the project. Once this happened and they have this financial disability, there is a committee within the DLD. It's called Cancel Project Committee. So they review this type of projects, which has this financial distress, okay? And they issue this decision. This committee, they get together and they convene a meeting at least twice a month, okay? So, and they take the decision regarding these projects. Once this project is canceled, they issue a decision for the cancel project and they suspend the escrow account, okay? No money comes in, no money comes out, whether to the investors or the developer, okay? Until a very long process where this cancel project go to Dubai courts, another judicial committee at Dubai courts decide about the fate of the investors within this cancel projects. And this actually ties in with a very important point I told you about, is that you need to sign Aqudi. Because if you don't sign Aqudi, the cancel project committee within Dubai court, when they are reviewing the project status and the escrow account and how much is in the escrow account and who invested in this project, you will not be regarded as one of the investors because you don't have Aqudi. So you don't appear in the government system. So you must have Aqudi in case the project went to cancel projects committee, they at least consider you as one of the investors. And when they are making a redistribution, proportionately, of course, to the investors, they count you in. So if you don't have Aqudi, they will not count you in at all.
But my question is about first, how long does it take? How long does this process take? It's number one. Number two, as an investor, what's your turn in distribution? Because there are also loans from the banks, from the developer and stuff.
Yeah.
So who gets the money first and who gets the money last?
Okay, that's a very good question. So in terms of timeline, I have to say it's frustrating because it might take, if not months, years, okay? Between the time the project goes to the cancel project committee within the DLD, decision issued to cancel the project, to go to Dubai courts, another decision, and in Dubai courts, it will be a judgment. So recently, for example, I had a judgment for a cancel project for 2 of my clients, and they're Russian as well, by the way. And the table in the judgment of the investors is more than 550 investor. And each one comes with his proportionate from the escrow account. So my clients, for example, they were buying a whole store, okay, of I think 6 to 7 apartments. And that was for 27 million. They got 9 of distribution.
This is as much as they can
it's
get.
It's proportionate, you know? So it's like 1/3 of what they paid, literally. So you pay 100%, or what you paid is 100%, you get 30%. Because what's left in the escrow account will give you 30%.
One of the things I want to ask about in this case, when we talk about the project, maybe it stopped when the development of the building is like at 20% or 25%. Does this progress will be considered within the valuation of whatever remains, or we talking only about the cash in the escrow account?
Only the money in the escrow account.
So whatever
this
assets
project will be cancelled, it will go back to the government or whoever who owns this. Sometimes it's big developer, because the developer is not the one who's constructing the project. You know, there is a difference. So sometimes the developer just own the land and they sold it to another developer, you know? So it's only the cash available in the escrow account that will be distributed on the investors, okay? And proportionately. So if you were paying 50 million your amount you will get is different than the person who paid 30 million, different than the person who paid 15, etc., etc., etc. That's in terms of the timeline. So the timeline is really long, okay? It's long to the point where you have a decision that this is your amount that you will get back. There is another phase after this is how do you get this money back? Okay? So it's a hassle, I have to tell you. That's why I'm telling you, if you're making an investment that big, you need a lawyer. And we keep saying this. Get a lawyer if you're making this investment. It will save you all of this hassle. So how to get this money is another dilemma. So you have to open an execution court case within Dubai court or Abu Dhabi court or whatever. You have to pay fees to the court for execution, and you have to wait in the line as well for distribution of this money. Okay? Some issues happen, and I'll tell you behind the scenes. If you have invested this money, you and another partner, for example, 50-50, how would you get the money back? You will get it 50-50. But how you will get it 50-50 back? They will tell you it's either going to be issued by check in each partner name, personal name, or we will make a wire transfer to each partner account. Okay? Knowing the matrix of the UAE and the investment, diverse investment in the country, there is a lot of people that invest in the country, but they don't live in the country. That's correct.
Yeah,
you can confirm this, right?
Accounts and
they don't have a bank account. They don't have KYC documents. They are not residents, and they are not physically here. So they cannot take the money. If they take a check, how would they cash it? Can they cash it by proxy? No. The court, would it make an international bank transfer? No. So you need to come here. You need to have a visa.
So basically you will spend the whole return.
Exactly. So again, goes back to get a lawyer, because the lawyer will oversee this from the beginning and he will tell you.
Yeah. I mean, I understand this very well. Due diligence might seem like a bureaucracy, might seem like an extra cost on the deal.
Yeah, and they say, we don't want to pay good money over bad money. No, it's not bad money at all, believe me. When you come back to me and I charged you hundreds of thousands of dollars just to get you this millions, you will understand why you would have saved this in the beginning.
Going back to the investor interest in this, we have seen, or it's quite common in any real estate market that is doing very well, that brokers and brokerage companies, they tend to oversell the properties and oversell the ROI. Have you seen in the practice, I'm not talking about your previous employer, I'm talking about in the market, have you seen that real estate brokers are overselling the properties and have they caused distress to the investors who are getting not the correct information about the ROI? Or even the developers who are promising officially in their marketing materials guaranteed 8%, 9%, 12%, I've seen it, ROI for their investors?
First of all, normally developers, they're not involved directly in the information, this kind of information. So the launch is done by the marketing company, which is completely separate company, which signed an agreement with the developer to do the launch of the project, where they invite brokers. They talk to the brokers, all the managers, they, exchange the numbers, chatting on WhatsApp, saying, yes, this will be 8% of return on investment, 9%, above 9%. And as a broker, you need to understand that this is impossible. It doesn't exist. You cannot get this amount of money if it's, for instance, something like hotel apartments or something, and you have a rental pool agreement with you and 400 other people. So this is a lot of money. And there is a high season, there is a low season, people are coming and going, and the prices are different. As we know, during the summer, the prices are going down in old hotels, even the most expensive ones. So, plus Ramadan as well, not that popular timing. Then what happens, they trust the broker trusts the marketing team. They don't check, they don't even think that this is impossible. In my opinion, I think if you are a grown-up person, you should understand this. We're not children. And then what I saw was even worse. So it was 9% ROI promised within the year. People were signing SPA with the developer. The ROI was promised from the marketing team from completely another company who was doing the launch. They signed the SPA. SPA obliged you to sign the pool agreement, rental pool agreement. You sign it with another company because rental pool is managed by another company, the manager of this building.
Yeah.
You want to kick out, what do you need to do? First, they say it's impossible. You say, I want to opt out. Impossible. I look at the contract. It says you need to give a notice within 90 days from the opt-out. We will send you an opt-out agreement. You sign it, and then you can use your apartment. Fine. First, they said no. Then they said this clause is not working anymore. But it was never cancelled and nobody agreed. Nobody signed extra documents saying that this clause is not working anymore. So I helped the client to kick out. After 90 days, they send them an opt-out agreement, which states only you can live in this apartment or your first relatives. But if they come there, you need to be in this apartment together with them. You cannot rent it out. And if you are selling your apartment to somebody else, this person will sign SPA and rental pool agreement. So it's catch-22. You stuck. And then everybody knows about this project. It has a very bad news and nobody wants to buy a property.
It's basically we will own you and we will own whoever comes from your side for 99 years from today.
Yes. And the client, when she signed an opt-out agreement, it's been 6 months since she bought the place and it was running. Her ROI was 0.49% out of 9% of promised ones.
This brings me to a question, because I know in other real estate markets, for example, marketing materials are legally binding. So you cannot advertise 12% or 8% or 9% and don't deliver. So even if it's not in the contract, the marketing materials related to the project you are selling is a binding information that is part of the promise you make to your investors. Do you think an argument like this would stand in court in the UAE?
Well, if we look at it from a pure civil law perspective, not a real estate thing, it will stand. Because any contract, it has 3 conditions to be a valid contract. You have promise, or let's say offer, and acceptance and consideration. Okay? So if any of these conditions is built based on a lie or based on untrue information or misrepresented information, it's basically fraud, civil fraud, so misrepresentation. So if I'm an investor, I sit down with you, you promise me something, and based on that promise, I take it as a decision to get in contract with you. If this promise appears to be untrue later on, and you can prove this, then your intention to buy the property is based on something wrong, then it's invalid. So here's the entrance. Here's where you can break it from a legal point of view. However, this is theoretical.
Yeah, because you have an SPA and it doesn't include your 9%.
That's one, number one. Number two, as you have mentioned, most of the time, the marketing company is different than the developer. So when things actually happen, the developer will come and tell you, I've never promised you this.
And they say,
where it's written in the SPA.
This person is not working in our company anymore.
Exactly.
So that.
And then the marketing company will come and say, if you bring them or join them to the proceedings, they will come and say, we didn't sign anything with you to promise you this. It was just a marketing campaign. And what we have even seen, not in a very similar situation, they say, oh, this was just an indicative figure. It's a speculation. Don't take it to the heart, okay? It's not written in your SPA, just a marketing campaign, and it's indicative figure, and it's all over Dubai. It's not only us. Everyone says this is the normal return of investment in the UAE. Market crash, what can we tell you? This is the risk of investment. So from a theoretical point of view, you can. But from a practical point of view, the only party who will be benefiting from this is us. When you come to us and we file a case for you and take fees. So to be very honest, as I told you before, we have to be very honest with our clients. Just get a lawyer from the beginning, because it's a disaster, and the legal repercussions of this is not easy to deal with later on.
Yeah, this is one of the things that I believe it would help a lot. the market to be more reliable and with better reputation and actually more stability if real estate brokers, all the stakeholders in the business, in this real estate brokers, the brokerage companies themselves, the developer and the marketing companies working for the development, promoting these projects, will be held accountable to their information. And someone will say, you cannot promote something like that unless it is something that you can deliver. And if you promise ROI of 1 or 2 or 3 years of that percentage, you are liable to it if the investor is not making it. That would probably transform the market into a more trusted and more stable market. So they do not overpromise numbers that doesn't make sense.
Agree with you. Agree 100%. But it's the ugly truth, as they say.
Yep.
Putting more regulations would maybe stringent the surge in the prices, or make it harder to make profits, or maybe make it less interesting market.
I'll tell you what. It's very interesting that you only as a legislator you put this more regulations when actually let's say a precedent happen. So once someone has enough courage to take one of these marketing companies, okay, to court and have a precedent, then I think there will be some change in the market. This is what I see it.
Yeah, but what I agree with you. But what I saw when I told to a few of the clients, this is the length of the court proceedings, this is how much you need to pay, this is how much you need to wait, and they were like, "Oh, we better try to resell this property." They don't want to go in there. That's it. They're scared.
Then we come to a different thing. I mean, in other jurisdictions, you find a lot of litigation funding.
Yeah.
There are a lot of companies and insurance companies providing financial support to such litigation. Of course, it needs to have a kind of a criteria that they also have to benefit from it. But we don't see a lot of litigation funding in the UAE.
Well, there is actually. I've been contacted by a lot of companies for the past couple of years, but there is no legal foundation for the litigation funding in the UAE. So it's not, from a legislation point of view, it doesn't exist. There is no special law for litigation funding as opposed to other jurisdictions, maybe Europe, Canada, and the US. But how people actually deal with it from a practical point of view is like they sign some kind of an assignment agreement for assignment of rights. So basically they buy your rights, okay, chip in. If you have like a debt or any kind of a claim for, let's say, 1 million dirhams, they buy it from you for like maybe 20, 30 cents for a dollar. Okay. And then they file the claim on your behalf, or based on the assignment agreement on their own behalf, they collect whatever they collect more than what they have paid you of 20 or 30 cents for a dollar, they take it to their own pockets. But it's not very practical, to be honest, in the UAE, and it's not very common.
Going back to the transactions, I would like to ask you about what is the difference between the regulation and the practice whenever there's a buying and selling of a real estate property in regards to the security check. There is an obligation for the buyer to put a check for the property, and I think this is a practice as well. How does that work from the practical side?
Well, from the legal side, there's supposed to be 2 checks, one from the seller and one from the buyer for the 10% of the total price of the property. The buyer gives the check to the broker of the seller. It should be held by the broker of the seller. And as per the Unified Sell Contract Form F, they cannot cash it. So this is uncashable check, says that in the form, and it can only be cashed if both parties, seller and the broker, agree that the deal didn't go through. One of the parties is guilty, and they're like agreeing in writing that, okay, this check can be cashed out, or by the decision of the court if the parties do not agree. This is the law and this is the form. In general, as I told you, only the buyer is given the check, and then anything happens, nobody can cash it out, and you need to go to the court. And the buyer is saying, no, I don't agree. It's not my fault. And things are going there. People, in my practice, there was only one court case, but normally the brokers with whom I was working, they were managing to find another new buyer within the short period of time. They said that they agreed on 0 commission or half of the commission, but they will find another buyer and they will just help them to resell the apartment very fast. And it happened. So this is actually a good option to not to go to the court. But if the broker is willing to, keep the client and make the client happy and do this kind of stuff.
This is from the transaction side because the 10% is basically a guarantee between the buyer and the seller in the Form F, the initial sales agreement, that whoever pulls out of the deal for no legitimate reason should let's say, pay a penalty of 10%. Part of this penalty is basically, I think 20% of the penalty goes to the brokerage company that was involved in the deal. How is it in the practice? Because as it seems like the practical transactions happen that the sellers do not give this guarantee check. How is it in the practice if the deal falls apart and the buyer have put the security check and they're not able to recover it again?
Well, in practice, as usual, it's very different from the theory. So I'll tell you one interesting case we had. We had a client who paid this check, and this check actually how it works is that, as she mentioned, it stays with the broker as an escrow. So the broker during this time, his liability is the same liability of an escrow. He should hold the check, he should not return it to the buyer, and he should not hand it over to the seller at the same time unless the deal go through. So how the courts looks at it from a practical point of view is that, for example, in the case we represented many clients, but I'll give you one example, is that the court always look at the reason why the deal did not go through. Is it because of the buyer pulling back, or because of the seller, for example, found another better price, and he retracted his decision to sell this property to this specific buyer? So what we see in practice is that, for example, the Form F says that as an obligation on the buyer, he will continue in the deal and he will buy only subject to being able to obtain a finance. Okay? So for example, this wording, if it's not written black and white, very clear that it is what we call in the legal a condition precedent, okay? It has to be mentioned as a condition precedent, because otherwise he will come back and he does not have the financial liability to go through with the deal. So in his mind, it's a very valid reason why I'm not buying the property. I don't have the price of the property, which makes sense. But if it's not written black and white in the agreement that this would be a deal breaker as a condition precedent, then it's your fault. Then you lose the 10%. But you lose the 10% does not mean that the brokers go straight away based on his own interpretation and own volition and give the check to the seller. It doesn't work like this. The broker has to wait for either amicable resolution between both of them. That's one. Two, he has to wait for the DLD, because sometimes the buyers or the sellers, they complain to the DLD and the DLD takes a decision based on the documents. Or if someone sued the other, the broker still has to keep holding to the check until there is a court case issued. In my case, a court judgment is issued. In my case, I'm telling you about is that actually the broker handed over the check to the seller without the permission of the buyer, because he was too enthusiastic that he wants to close this deal and take his commission, which is a problem. Okay? So the seller, what did he do? He cashed the 10% on the basis that this guy is he gave me a check, is very serious about the transaction, and then the guy couldn't provide the finance. Then he came back and said, there is a rejection on my loan application. What do I do? Then the seller said, you never mentioned that you will not buy unless there is a finance. Then he comes back and say, no, it's written in the agreement. And when you look at the agreement, the wording is not clear. Okay, it doesn't say specifically subject to being eligible for a finance within this period of time, for example. No, It doesn't say that. It says that the way of payment is finance. So way payment of finance, it assumes that you have a finance approval, you have a bank approval for your home loan, but this is not the case. So all of this stuff need to be very clear in Form F, and the seller need to understand his rights and obligation, buyer need to understand rights and obligation, and the agent in between them, he needs to understand his rights and obligations as well, because he cannot sell the buyer and give the seller the check, and at the same time cannot return the check to the buyer. You know what I mean? He's an escrow and he has a legal obligation. Sometimes in some cases, actually, we get the real estate agent as a party to the case. Okay? And we ask for damages. In this specific case, we did so because he handed over the check illegitimately to the seller. Because they have an interest in cashing the check. They take 20%. So they will take 20% of a deal that didn't go through. It doesn't make any sense.
Yeah, absolutely. And this kind of involvement of the real estate brokers and the brokerage companies is why the regulator have made these courses and make these code of ethics for real estate brokers and make these education courses for all of them. And I think this is one of the things that you were taking care of in your company, that you were focusing on what the brokers need to learn in order to do their job. How was it?
Yes, that's correct. So when I joined the company, I asked the HR team to provide me with the slides from RERA for the brokers. So it's 400 slides I went through. I was really surprised that the slides were all in Russian. So I gave them a question to our company, not our company, to the company, let's say. Was this training in Russian? And they said yes. And it shocked me because out of all the brokers who are working in the company, 80% of them didn't speak any English. So how can they close the deal in the country where the main language is Arabic or English? And I think this is an essential. The broker should not only do the RERA test, but he should do the English language test to close these deals. This is very important because then even he or she doesn't understand what some document says. They're like, oh yeah. I said, did you read this document? Well, yeah, I looked at it. We looked through the translator. You cannot trust Google Translator 100% or any other translator. Like, you need to understand what you are doing. And if you don't know the language or the level of your knowledge of English is, I don't know, first grade, then how can you be a broker? This is a very important thing. You need to know English. And all the training should be in English.
Well, guys, thank you so much. It's an amazing discussion. And I think real estate is one of the topics that we will keep inviting you to talk about it. We talked with huge focus today about the investor and the real estate brokerage and the developer side. And hopefully next time we invite you for different topics about real estate. Thank you very much, Mohamed, for coming.
Thank you, Ahmed.
Thank you, Veronika.
Thank you.
Thank you very much, everybody, for giving us the time. And this is your dose from Monday Legal. See you next week.